Hey, hello everybody. Welcome back to one of our live streams. As you can see, I'm from some new digs here that are in the process of construction. So yes, in fact, it's been a busy period for me, moving house and trying to kind of renovate the new one and demolishing everything in the process. So it has been busy, but perhaps not as busy as it has been for you guys preparing for the SQE. Now we've got some people live. Perhaps you can tell us whether you're preparing for the sitting in July or whether you're preparing for the next sitting of SQE1 that's going to be coming up in January 2026. Either way, you're very welcome to the chat, very welcome to this live stream. And what I'm going to do, I am going to have a set of live streams every Tuesday. Now that I don't have to kind of keep carrying boxes from one place to the next, every Tuesday at 12:30. And I would like these streams to be a focal point for the community. So other candidates can get together, you guys can chat while we're live, or you can use the comments box that's under the stream when you're watching it on the recording to communicate with other candidates, talk about your experience and how everything is going on. Now, the idea is to have them as interactive and as engaging as possible to help with this sense of community that we're missing. And I wanted to say a couple of things about this, because I was in a meeting with the SRA recently, and okay, I don't know whether I'm supposed to tell you this stuff, but I'm gonna tell you anyway. The SRA is very keen on projecting an image of a success about everything SQE related. Now, unfortunately, from our perspective, so from the perspective of the providers and from the perspective of the candidates, I don't think we are necessarily full of praise and appreciation for the SQE. I mean, I don't know. You can tell me how you guys feel about this yourselves, but so if feel free to put your opinion politely in polite language on the chat that you've got right on the screen here. But the experience of most providers, the experience of most candidates, the experience of us at academic institutions or as tutors for SQE candidates has not been fantastically positive. So it's not that the previous system with the LPC was fantastic and everybody was having a great time, but since they introduced the SQE a few years ago, we've been having trouble that we're coming back to again and again and again. Now, by the way, if you're new to this whole process and you just kind of tuned in and you don't know who I am or what I'm talking about, I'm Dr. Yanis, and I'm here to help people who are preparing for the Solicitor's Qualifying Examination, abbreviated as the SQE. This is what you need to do now if you want to qualify as a lawyer or as a solicitor, as we call it in England and Wales. So this is what this stream is about, and this is going to be a series of streams that takes us up to the next examination date, which is in July this summer. Right. So I was saying that I was in a meeting with the SRA, who's the regulator, recently talking about the experience of the SQE. So the SRA is very committed in projecting a positive view of what has happened. So they're producing all this documentation showing how well they've done in this and well they've done in that, and how it all kind of builds together into a positive image. And I was saying earlier that from the point of view of the candidates and the point of view of us teachers, it hasn't been really that fantastic. Nonetheless, it is what we all have to do now. There aren't many people who are still qualifying to go under the previous regime. The previous regime, as you will probably know, was the LPC, the legal practice course. So people would graduate with a law degree, then they would enroll to the legal practice course, which cost a ton of money. And at the end of it, if they passed their examinations and so on, they would try and find or move on to a training contract with a law firm. And at the end of the training, they would qualify as solicitors. This pathway has closed for people who have started their law degree from 22 onwards. So anybody in here who is relatively fresh wouldn't qualify for this anyway. Anybody who's an older graduate might qualify for the new route. And you might be wondering, is there a point in going under the old route if you still qualify for it? I've got a couple of videos actually discussing the differences between the LPC and the SQE that I can link down in the description and you guys can see later. But as we're here, you shouldn't. If you're wondering, if I'm eligible, can I do it? Don't do it. And there is a very good reason why you shouldn't do it. The reason is there are no more training contracts. Hardly any law firms and hardly any decent law firms from the big ones that most people want to work for still offer pathways to qualification through the training contract. They just don't do it. They've told everybody we're accepting people through the SQE. The problem is, and this is a bit confusing, the law firms, especially the big ones, they still use the terminology training contract, even though technically under the SQE you don't have a training contract, you have a qualifying work experience. So the law firms are still calling it a training contract, but they don't make it available to people who are LPC graduates. So anybody who's in an LPC graduate has ended up in this limbo, having completed the study and vocational part of their qualifications, and now waiting to find a training contract with somebody, but they don't find one because the law firms are telling them we only accept people who've gone through the SQE, which leads to the despicable outcome of people having to sit the SQE even when they have completed the LPC because they're not able to find a training contract. Now, just in case you're wondering, what they call now the qualifying work experience is different from the training contract because it doesn't need to be a structured period of work in a law firm. What counts as qualifying work experience is work in the legal domain, broadly defined, not necessarily in a law firm, under the supervision of a solicitor. That's why people who've been working as paralegals, or they've been working, say, in a claims department, or they've been working in-house in a contracts division, or in a sort of IP data protection context, if these people were qualified by a solicitor, were supervised by a qualifying solicitor, the time that they spend working there, either before or after the SQE, counts as the qualifying work experience, which means that they can tick the boxes and then they can qualify. So you no longer need the traditional training contract in the law firm. Now, clearly, if you wanted to work at a law firm, then the time that you're going to spend working there is going to count towards this too. But be mindful of this difference in the terminology. I also got videos explaining what the qualifying work experience is, and I've got videos explaining how this relates to people who are qualified overseas, because your overseas legal work also counts towards your qualifying work experience. That aside, the SRA has been telling us that everything has gone fantastic and everything is going great and all the stats are positive and all the candidates are happy and the outcomes are better, etc., 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 even though we know that in reality they're not. And the situation that we're dealing with is that now the SQE remains the one and only secure pathway to qualification. So anybody who tries to do anything else might run into trouble. So if you have any friends or you qualify yourselves for the previous route, forget it. I don't think it's going to work. Sorry, I know it sounds negative, but it is what it is. I mean, you guys don't come to these live streams to listen to kind of rosy tinted presentations, right? You come here to listen to the raw truth as it is. If you guys want the raw truth, stick us like an emoji down in the chat, or kind of hit something, or hit the like button. I've got a few people watching live, which is awesome. So, show us some interaction that you appreciate the kind of raw info that's coming out of me in this kind of unpainted room that I'm sitting in. Right. So what we've got coming up, and my best wishes if you guys are preparing for this, we have SQE coming up in July. So we're going to be meeting every Tuesday at 12:30. Live here, me and you and the rest of the community, and we can have a discussion. You can also find us all together in the Facebook group. I'm gonna put some links to this down in the description later. And if you are channel members, meaning the people who pay me $2.99 a month in order to be part of the inside community. We have a special Facebook group just for the channel members too. So again, I'm gonna put information for that down in the description. By the way, if you want to become channel members and spend the price of a coffee, even though the coffees have become more expensive now, I don't even think you can get an espresso in London for $2.99. But if you want to spend $2.99 on me, then you can become channel members and you get all the videos straight on. I'm producing now memos and notes and infographics that are going for the channel members too. So all of that stuff and a bunch of other freebies are coming your way quickly. And since I'm doing promo stuff, are you guys registered to the newsletter? I've got a newsletter, goes out every Monday and has nice MCQs for you to practice for the SQE. And having said the magic word MCQs, right? Shall we try some MCQs together and see how we do? So what I'm going to do is I'm going to attempt to share my screen and show you guys some MCQs. Now, usually when I try this, it works. On occasion, everything crashes. So let's see if we manage to do this today. So let's see, we click this, and then we click this, and there's a, you need to click them in a specific sequence, otherwise it goes a bit whoopee. Okay, so let's see where we go. Ta-da-da. The screen changed, ladies and gentlemen. Aha! I see things happening. So perhaps it has changed. All right. So it shows, yes. Isn't that lovely? So now I have reduced to a small man, like a miniature Dr. Yanis, right at the bottom right-hand side of your screen, and the rest of your screen using the questions with the SQE prep. So are we ready to attempt some MCQs? I have pulled them at random from questions that have appeared in earlier versions of the newsletter. The newsletter, by the way, it's running into number 88. 88 for 88 weeks. Every Monday, I've been sending out the newsletter. Isn't that awesome? 88 weeks in a row. I just had one interruption for Easter Monday this year, but otherwise 88 weeks in a row. So subscribe to the newsletter. I'm going to put this in the chat. So it is newsletter at glintis.co.uk. Email this with the word subscribed as your subject matter. And then you're going to be in the lucky position to receive this and fresh MCQs and tips and discount codes and everything else every Monday. Okie dokie. So let's have a look at our first question. All right. Let's see what's happening here. XYZ PLC is a public limited company that wants to raise additional capital by issuing new shares to the general public. Which of the following statements best describes the process of issuing new shares in a public limited company? Is it 1, the company can issue new shares to any individual or entity without any restrictions or approvals? Is it 2, the company only needs to obtain the approval from its existing shareholders to issue new shares? Is it 3, the company can issue new shares without any formalities as long as it complies with the relevant legal provisions? Is it 4, the company must submit a prospectus to the regulatory authority and obtain permission to offer the new shares? Or is it 5, the company can issue new shares only to its directors and employees as part of an employee share scheme? All right, what do we think about this? So a public company that wants to raise additional capital, right? Which of the following statements best describes the process of issuing the new shares? Shall I give you a moment to think about it? Do you need to think about it, or do you have the answer ready? Okay, let's have a think. What is the correct answer? The correct answer, ladies and gentlemen. Come on, what happened here? Something went away. So the correct answer is number 4. The company must submit a prospectus to the regulatory authority and obtain permission to offer the new shares. When a public limited company such as XYZ PLC wants to issue new shares and raise capital, it is required to follow certain procedures and comply with applicable laws and regulations. They cannot just willy-nilly do whatever they want. One of the key requirements is the submission of a prospectus. That's the legal document that provides detailed information about the company, its financial positions, the purpose of the share issue, and other relevant information to potential investors. Issuing new shares in a public limited company will normally involve offering them to the general public, allowing individual and institutional investors to purchase those shares. The process aims to ensure transparency and protect the interests of potential investors by providing them with comprehensive information about the company and its financial prospects. So, correct answer here was 4. Yeah. So they cannot do whatever they want. They cannot pick people to give the shares to. If they're issuing new shares, they need to give everybody the opportunity to obtain them. And if they're a public company, they need to do this in the open market. And they also need to comply with all the regulatory requirements as set by the Financial Conduct Authority, which involves the creation of a new prospectus. Now, there is a great deal of things that need to happen for a public limited company to be able to engage in transactions with its shares. More of this on related company law information. I've got a variety of videos on company law that I cover, also stock markets and listing rules and things like this that you can find if you have a look around the channel. I've even got a marathon session that covers the totality of the syllabus of company law from beginning to end. And it is a long lecture podcast that goes on for nearly 10 hours. And you must be thinking, this guy is crazy. Who the hell wants to sit through 10 hours of company law lectures? The answer is, I don't know, do we have anybody in the audience from India? If we do, or if you're watching it later on the replay, just say me down in the chat. In India, marathon lectures are super popular. So a lot of people are kind of sticking together the various lectures that they've delivered that could be like 30, 45 minutes, an hour or something. They're sticking them together into a long presentation, which is awesome, because that way you've got the benefit of starting a topic, and then you can kind of pause it when you don't want to continue. But when you come back to it, you find it exactly at the point that you left it. And I think that's the logic behind the marathon video, that you can always continue from where you left off. So you got, for instance, multiple devices. It could be that you're watching at home on the TV, then you're watching at the computer at work, then you're watching on your phone while you're commuting. If you're following the same video, it will always pick up at the point that you left it before. If it was on a playlist that's taking you from one to the other, I think this is a little bit more difficult to achieve, and you might get lost in the different videos. So I think it's like my suggestion. Tell me if you think otherwise. I think that's the reason why these marathon lectures are actually very popular, and they've caught on in India, as I said. So I was trying to replicate the same thing to see if the audience enjoys this type of thing. So if you're into a 10-hour company law lecture, then I have one for you. Yeah. Are we ready to move on to our next question? Okay, let's see what we've got coming up. Now we have a different company with a slightly different problem. We now have XYZ again, but now there's somebody else. They are a limited company. XYZ Limited is a private limited company with multiple shareholders. The company's articles of association state that any transfer of shares requires the approval of the existing shareholders. Jack, who's a shareholder of XYZ, wishes to transfer his shares to a third party without obtaining the approval of the existing shareholders. Which of the following statements best describes the situation? 1. Jack can transfer his shares freely without obtaining approval from the existing shareholders. 2. Jack can transfer his shares without approval if he notifies the company in writing within a specified time frame. 3. Jack cannot transfer his shares without the approval of the existing shareholders as per the company's articles of association. 4. Jack can transfer his shares without approval if he sells them at a fair market value determined by an independent valuation. 5. Jack can transfer his shares without approval if the company's directors provide written consent. Aha! What do we think? Is it 1, 2, 3, 4, or 5? Remember that this is a private limited company. Limited companies have got very different requirements from public companies. Strangely enough, in English law, there is no different statutory tool that governs private and public. We don't have different ones, we have one. Everything is in the Companies Act. So the Companies Act is meant to give you the fundamentals of corporate organization, regardless of whether you're having a private limited company or you're having a public limited company, or you have a public limited company that chose to be in the stock market. Remember that a PLC is not necessarily in a stock market, but a PLC has the option if they want to list in a stock market. Now, all of this is governed by the Companies Act. All the information that, or at least the starting information on the regulatory regime is going to be there. So what does the Companies Act require when somebody is trying to transfer shares in a private limited company? This is always more difficult than the public. The whole point of the public is that members of the public can obtain the shares without the involvement of the corporation itself, so people can freely sell to each other. This is not what's happening in private limited companies. So the correct answer here is number 3. Jack is not allowed to transfer his shares without the approval of the existing shareholders as per the company's articles of association. The situation described in the question talks about the transfer of shares in XYZ Limited. The company's articles of association, if they're based on the model, which they probably are, state that any transfer of shares requires the approval of the existing shareholders. This provision is common in private limited companies where the shareholders often have preemptive rights or restrictions on the transfer of their shares. In this case, Jack, as a shareholder, cannot transfer his shares to a third party without obtaining the approval of the existing shareholders. The articles serve as a contractual agreement between the shareholders and the company, and they define the rights and restrictions associated with the company's shares. It's important for shareholders to adhere to the provisions outlined in the Articles of Association to ensure compliance with the company's internal rules and regulations. And I think that that's a good thing. It reminds us of the importance of the articles, right? Because I mentioned before that the Companies Act is the key legal tool that shows us how companies are governed in English law. But the next thing that one needs to have a look at is what happens with the articles of association of the company itself. This is what the company and the shareholders choose for themselves. Now, you must remember that most of the time, people don't sit down and kind of brainstorm and kind of go, what shall we put in our articles of association? Normally, people take the model that is appended to the Companies Act. They take that model and they adopt it. So if you want to start, okay, let's have a chat about this because that's an interesting topic. Does anybody in here have their own private limited company? Has anybody set up one or is thinking about setting one up? It's very easy to do these days. What I did, for instance, for my own company, is that I went to one of the internet banks and that offer business accounts, and I said, I would like to open a business bank account. They said, great. They said, do you have a company or would you like us to set one up for you? Right? So I hadn't set up the company already. I just went to the bank. I said, no, I don't have a company. I would like you to set one up. They went, what name would you like for your company? I said, I picked a name. I had thought about this in advance. Obviously, I picked up a name. They said the name's available. I said, great. They said, where would you like your company to be located? So then you chose jurisdiction and you gave an address. They said, would you like to provide your own address or do you want us to set you up with a virtual office? I chose the virtual office because it's always a better idea to have your company registered in an independent location rather than your own house. So that way, the whole world doesn't know where your home address is. So, if you've become like a super successful one day, you probably don't want people knocking on your door, yeah? Or if you owe people money, which is even worse, then you definitely don't want people knocking on your door. So I chose the virtual office. Then it said, we're gonna set your company up and do all the paperwork with Companies House for free. This is like an offer from the bank. And then they asked me, would you like us to set up a web address for you, like a website? Would you like a domain name? At that, I said no, because I wasn't ready to do that at that point, but they could have done this for me too. Then we did some ID verification things, as you're probably used to this every time you open a new bank account. It wasn't anything more onerous than this. And then that's it. Bingo. You paid with a credit card or a debit card the initial registration fee that was not for Companies House, and it was not a fee for the bank. It was just the fee for the virtual office, because for that, obviously, you needed to pay something, right? So they then said, okay, all done. Wait to hear from us. Within an hour, I get confirmation that says everything's okay, the name's okay, the address is okay, everything works out, no problem. Wait for your certificate. Within 4 hours, I received a certificate from Companies House that everything was set up and the company was ready to start operations. So the whole thing happened in an afternoon, right? And I forgot to mention, and that's important, that's why I started talking about this. It asked me, what would you like to have as the articles of association? And it said, would you like to adopt the model articles that are provided by law as a template for your private limited company? To which I ticked yes, and then that allowed the whole process to be super easy. I could have chosen something different and upload my own document, or I can come back to it later and change and amend and then notify Companies House. But choosing the model articles is the sort of baseline for everybody, and it covers all the things that you need and all the things that you don't know you need. So because, who's going to think about all the details unless you've studied company law extensively, or unless you're like a professor of company law, you wouldn't know all the ins and outs of what needs to be in the articles of association, because that's the internal constitutional document of the company, and that's very important. It is the document that explains who does what and how and when, and what's the relationship between the board of directors and the shareholders, and whether things can happen or not, and what is the process. So this isn't something that you can just ad hoc. So everybody selects the model articles, and that's the way to go. Now, this question here gave you information about what was happening in the articles already. If it doesn't, if you come across a multiple choice question that doesn't tell you what the articles say explicitly, assume that the company has been built on the model articles of association. If you're getting a date, the date is not to be ignored. It's important because they refresh the information on the model articles. So the model articles that are applicable for companies that are establishing now are going to be slightly different from the model articles that were in force, say, in 2005 or in 1985, yeah? So if there's a date in something that you're doing that tells you where the company was established, it might be significant because it might point you to the correct style, to the correct pro forma for the articles that you're looking at. So this is unlikely to happen in the context of an MCQ for the SQE, but have this in mind just in case you come across it. So if there is no specific mention of what the articles say, assume that the company has adopted the model articles of association and take it from there. As we said, to conclude this, the correct answer here was number 3. Jack cannot transfer his shares without the approval of the existing shareholders, because that's what it says in the company's articles of association. Okay, if you guys are enjoying this and if you find this useful, give me like some message on the on the chat, or hit the like button if you're watching on the replay, so I know that you guys are having a good time and you're finding this information valuable. And of course, if you're watching this live, we got some people here. Feel free to put a message in the chat or an emoji or something to let me know how you're getting on. Yeah. Okay, now we are ready for our next question. The topic today is kind of broadly company law, because I thought that's an easy entry point into this. FLK business law contains what you will come across in company law, so it is as good a starting point as any. Or in any event, I spent many years teaching company law, so it comes kind of easy for me. Hopefully you guys are finding this information useful as well. Okay, ABC Limited is a private limited company with multiple directors. The company's articles of association grant the directors the power to make decisions collectively as a board. However, one of the directors, Alex, starts making major decisions for the company without consulting the other directors. Which of the following statements best describes the situation? 1. Alex is allowed to make major decisions on behalf of the company so long as they are in the best interests of the company. 2. Alex's actions are valid because the articles of association grant individual directors the authority to make decisions. 3. Alex's actions are valid if he informs the other directors of their decisions after they have been made. 4. Alex's actions are invalid as regards outsiders because the articles of association require major decisions to be made collectively by the board. Or is it 5? Alex's actions are valid as regards outsiders regardless of limitations in the articles of association. Okay, what do we have? So the 1, is it 2, is it 3, is it 4, is it 5? The answer is 5. Alex's actions are valid as regard outsiders, regardless of limitations in the articles of association. In a private limited company, the board of directors generally exercises its powers collectively as stated in the articles of association. Major decisions impacting the company's affairs and operations should be made collectively by the board. But Alex's actions of making major decisions without consulting the other directors go against the collective decision-making process established in the Articles of Association. We're not arguing about this. But this does not have external effects. Section 40 of the Companies Act of 2006 determines that external parties are not affected by internal limitations of capacity. Therefore, an act of a director violating the articles will be invalid as regards the corporation, but can still have binding consequences for the company and third parties. Isn't that interesting? The fact that something has been done wrongly or inappropriately, but it does not have consequences on outsiders, it only causes internal difficulties. Now, what do you think this is? I think the obvious answer is that otherwise, it would be unfair on the outsider. Yeah. So if I'm sitting here and somebody contacts me and goes, "Hey, we would like to hire you to do like a promo, and we're gonna sponsor a video of yours, and we're gonna pay you like £500 to talk about us in a video," and I'm like, "Yay, awesome!" And I start working on the video. I prepare the contract. They sign it. The director over there signs it, sends it back. I'm happy. I start working on it and so on. And at some point, they call me back and say, "Oh, you know what? We won't be able to pay you for this, and we don't actually want the video because when the board got together, they realized that influencer marketing is not what they wanted to go for, and the director that contacted you and assigned this work for you hadn't actually cleared it with the rest of us. So sorry, too bad. We're not gonna do it." You're like, "What? But it doesn't have anything to do with me. Why should I be the ones losing out? I've got a signed contract with these guys. So what's the deal?" So this is precisely what Section 40 of the Companies Act is trying to do. Is trying to protect outsiders who don't have anything to do with these problems from confusion or difficulties in internal decision making. It should not be my fault. I'm the contractor, okay? I'm the external business. It should not be my fault that the directors were not actually aligned in what they wanted to do when they hired me to do this job. So that's why the correct answer here is the last one, number 5, that says that Alex's actions are valid regarding outsiders, regardless of any limitations in the Articles of Association. Now, does this mean that insiders have got basically a free card to, like a get out of jail card, to violate the rules in the Articles of Association whenever they feel like it? No, we're not saying that, because any action of the directors that violates the company's constitution is a breach of duty. If you come across this material, you're going to see that one of the key duties of the directors is to respect the bounds of their authority. The bounds of their authority are set by the Articles of Association. If the Articles of Association say the board needs to collectively, all together, decide on stuff, and one of the directors kind of goes off by themselves, then they are violating the articles. They are breaching directors' duties because they're not respecting the duty that says stay within the bounds of your authority. If the company suffers loss as a result, then the company will have the right to go after the director that engaged in the violation and ask them to make good that loss. So if in this contract, for instance, something goes wrong, right? They've paid me in advance, I never give them the video, and it turns out that the company is out of pocket for £500. Then, since the assignment of the work was in violation of the articles, and the director then is breach of duty, it is the director that signed the contract with me that will have to compensate the company for the loss of these £500. Now, whether they're going to come after me later is besides the point. The important thing is, what is the consequence for the internal violation? So the consequence is, if the violation has caused harm to the company, there might be avenues, usually through breach of director's duties, to go after the director that has done the wrong thing. But so far as the third party is concerned, you cannot go to a third party and tell them, you don't have a contract, sorry, we made a mistake internally. It is only in very limited circumstances where the third party was aware of the director engaging in some sort of violation and they were in cahoots and so on, that you might be able to go after the third party as well. But remember, what's the key rule here? The key rule is that Section 40 protects third parties. Correct answer here is option 5. Yeah. More on this on the videos that I've got on business and company law that talks about directors' duties, corporate decision making, corporate governance, and all the rest. Have I told you guys this? I now have enough videos to cover the totality of SQE1 content. So I've got on my website, so if you go to the website where's the newsletter, glintis.co.uk, I've got a couple of video lists that gives you a breakdown of all the topics in FLK1 and FLK2, and it's got the link, it's got a breakdown of the topic in its totality, like contract law, we do contract terms, we do unjust enrichment, we do formation, we do remedies, we do all sorts of things. So it breaks down the topic per FLK for everything, and then it links to the relevant video. So there's a video that covers the totality of FLK1 and FLK2, the totality of SQE1. So you could actually use the YouTube channel and prep for everything. Not that you should only do this, you need to study a bit as well, yeah? But if you want a sort of audio-visual narration of the totality of the FLK for SQE1, you can do this through my YouTube channel. And so all the topics are already covered, but what I'm doing at the moment, I'm creating slightly shorter versions that are a little bit more digestible. So I've got a series where I'm doing like a couple of minute video explainers. These are usually explaining specific cases or areas of difficulty. And then I've got the 5-minute series where in 5 minutes, it kind of breaks down the topic. So I'm progressing this, and what I'm doing that I mentioned earlier is that now I'm adding some documentation. So channel members, these are the people who pay for that coffee, are gonna be able to download an infographic with a set of notes for the topics that are covered in the 5-minute series. So you get to watch the video that explains what's going on in 5 minutes. You get to download and keep or print out, if you want, the infographic to help you remember what's going on. And then you can go to the longer video that explains this stuff in detail. So it helps with your prep for the SQE. So all of that stuff is there already. Everything's available already for channel members. If you're the public version, if it's not available now, it's coming up. So all of that is there to help you guys with your preparation, and hopefully you enjoy all this. I'm very happy that I made it, and I'm very pleased with myself having covered the totality of FLK1 and FLK2. It took a little bit of reading for areas that I don't normally teach, like all the criminal law and property law stuff. But I am aware that it's probably going to be more unpleasant for you guys having to revise this stuff in depth rather than me doing like a single class on it. But there we go. Are we ready for the next one? Okay, let's give a shot to the next one. This one is DEF Limited. Is a private limited company with multiple shareholders. Amy, one of the shareholders of DEF, unfortunately passes away. Which of the following statements best describes the impact of Amy's death on her shares in DEF Limited? 1. Amy's shares will be transferred to her next of kin automatically upon her death. 2. Amy's shares will be transferred to DEF Limited and the company will cancel them. 3. Amy's shares will be distributed according to her will or the laws of succession. 4. Amy's shares will be offered for sale to the other existing shareholders at a discounted price. 5. Amy's shares will be transferred to DEF Limited and allocated to the remaining directors. Aha. Okay. What is going to be the correct answer here? The correct answer is number 3. Amy's shares will be distributed according to her will and the laws of succession. When a shareholder of a private limited company passes away, their shares become part of their estate. The distribution of the shares will be determined either by the shareholder's will or the laws of intestacy if there is no valid will in place. The deceased shareholder's next of kin or beneficiaries, as specified in the will or determined by the laws of succession, will inherit Amy's shares in DEF Limited. It is essential for shareholders to have a clear succession plan in place to address the transfer of their shares in the event of their passing. This can help avoid uncertainties and potential disputes over ownership and control of the shares. If you want to know more about this, I've got a video specifically on inheritance, intestacy, succession, and all the rest, illustrated by an awesome thumbnail of people kind of carrying a coffin. Have you seen that? Have you seen that internet meme where there's like a bunch of really happy people in a funeral kind of dancing along with a coffin and kind of singing? Yeah. This was on the socials like a few years ago. So when I was thinking, how do I make a thumbnail that looks nice for the intestacy video? I remember that meme and I made it on those lines. So hopefully you don't find it inappropriate and it's okay for you guys. But a lot more information about that and the laws of succession on that particular video. Important thing for our purposes here is that Amy's shares will be distributed according to her will and or the laws of succession. The reason for this is that shares are assets. Shares are property rights. When I was teaching company law, we were getting into these kind of lengthy debates as to the nature of shares. And the key dynamic was whether one should consider shares to be property rights or whether they are contractual entitlements. Of course, there are differences in the treatment of the two, right? Property law aims to connect the owner with the property in a more intimate way, meaning that it tries to preserve the links. Contract law, on the other hand, is interested in the financial value of the asset, not the asset itself. And that's the reason that when we teach contract law, we keep telling people that the primary remedy for breach of contract is damages, which is monetary compensation. So in a breach of contract situation, the court is not going to bend over backwards to secure the outcome. What they're going to do is estimate what is the value of that outcome and give you the money instead if you didn't get to that outcome due to the breach of contract. In property law, on the other hand, the primary method of compensating or addressing the problem is to keep you connected with the property that you've got, as opposed to estimating its monetary value and then compensating you. That's why we got into a bit of a mix-up. Like when I say we, I mean the courts, right? They got into a bit of a mix-up when they had to kind of parse these things and whether they had to decide whether shares in corporations should be understood primarily as property entitlements or financial assets. So should the property aspect of it or the contractual aspect of it take priority? Now, the answer is it depends on the circumstances and the problem that you're looking at. Sometimes they're treated more like property, sometimes they're treated more like financial assets. I will let you watch the relevant parts of my company law marathon lecture that talks about shares and these things in a lot more depth when you get to that point. Yeah, but it is an interesting discussion. It's come up in recent years in cases of government expropriation. When people were complaining that the government took away their assets and didn't compensate them adequately, and then they were arguing you shouldn't have taken it because the property rights, and the government was arguing, well, whatever, we compensate you to a degree on the basis of their financial value and we think it's okay. One of the funniest instances of this was the case in the US where one of the insurance companies that got rescued from the government during the financial collapse then sued the government because they argued that the valuation of the shares that the government didn't expropriate, but they bought in order to save the company, that they didn't value them adequately. And you're like, really? It was about AIG, right? AIG would have gone bust if the government hadn't stepped in to help. The government stepped in to help, and now you're pissed off because the valuation for the bankrupt company that the government saved wasn't adequate for your needs. But anyway, funny case. You'll come across it as an illustration and the details of it when you look at the marathon company law lecture. Yeah. Okay. I mean, there's so much fun stuff. You know what? You guys probably appreciate this more. Go on. If you appreciate this more, hit the like button down there. The people that I was teaching this stuff live in the classroom most of the time were asleep. They thought they were too young and they thought this stuff doesn't relate to their lives. But I mean, damn, we do have a great deal of really lively, interesting, again, exciting stuff in company law happening all the time. Get yourselves a subscription to the Financial Times. It's the best thing you're ever going to do. By the way, if we got any students in here from the Open University, right? Any of my OU students around here, if you are an Open University student, you get a free subscription to the Financial Times. Yep, money-saving tips. You heard that here first. Go tell your friends. So all you students get free subscription to the Financial Times. Booyah. All right. Let's move on to the next question. Or not. If I'm pressing the wrong button. Aha! There we go. What do we have here? We have ABC Limited. ABC Limited is a private limited company engaged in retail sales. The directors decide to issue new shares to raise additional capital. They have decided to do this without obtaining approval from the existing shareholders. The articles of association require the existing shareholders' consent to any issue of new shares. Which of the following statements best describes the validity of the share issue? Similar to what we said before. So let's see how you guys are going to do for this one. 1. The share issuance is valid so long as the directors believe that it is in the best interest of the company. 2. The share issuance is invalid because it was done without obtaining approval from the existing shareholders as the law requires. 3. The share issuance is valid if the directors notify the existing shareholders within a specified time frame. 4. The share issuance is valid if the company's auditors provide a written confirmation of its financial health. 5. The share issuance is invalid because the articles of association require approval from the existing shareholders. Okay. On the basis of what we said before, you guys should be able to get this. Okay, where are we at? Okay. Hang on. Yes. The correct answer is 5. Yeah, the last one. The share issuance is invalid. Why is that happening? Why is the share issuance invalid? So the share issuance is invalid because of the articles of association that require approval from existing shareholders. In a private limited company, the issuance of new shares requires the approval of existing shareholders, unless the articles give the directors specific authority to issue the shares without shareholder approval. A share issue can impact existing shareholders as the newly issued shares would dilute their holdings. Current shareholders can opt to buy the new share issue as they have first rights under sections 561 and 565 of the Companies Act. These are known as statutory preemption rights. Yeah? That's why you have to follow the instructions in the Articles of Association that we already said the Articles of Association are the internal command and control center of the corporation. They are the constitution of the corporation. So if the Articles of Association require something, this is what makes the rest of the process valid and appropriate. We don't have the problem here that we had before when we were talking about external parties. This is an internal situation about what the shareholders have entitlements to, meaning that if the directors get this wrong and they mess it up, then they're obligated to fix this. You don't have a kind of Section 40 situation with the outside parties that I mentioned earlier. So the share issuance itself would be declared invalid and nobody would attain rights when they try to purchase those shares if the process in the Articles of Association was not respected. So that's one of the things to remember, and it ties in really nicely with what we said earlier about what happens with the Articles of Association, what happens with shares, and all the rest of the stuff. So what I'm gonna do now, let me just stop this share. So I'm back full screen with you guys. How are you doing so far? Did everybody find this stuff interesting today? I've done this in a bit of a hurry. I should have been better prepared, to be honest. So I've got like a nicer visual in the background, but my office is not fully prepared yet. But soon enough, we're going to have like a nice live streaming space. It's kind of nice and clean and looks nice, and the lighting is nice, so we can have these discussions, and you can see me kind of looking great. Not that you care, but it'd be fun. So I can see myself looking great, and then we can kind of dive into the material. So what I plan to do the same stuff for next week, and then next Tuesday, and then next Tuesday, all the way up to the first sitting of SQE1. So what I'm planning is that I'm going to have a set of questions prepared. So if people are happy to do that and go through MCQs, we can do this together. If people want to discuss about something else and they let me know in the chat, or they send me a message in advance, or they put a comment under the video telling me something, then we can do that as well. So the multiple choice questions that I'm preparing are a sort of backup for our discussion. So I provide something valuable in the time that we're here, but I can, in addition, talk about other things if anything comes up here. So if you guys want to know about study prep, if you want to know about material and resources, if you want information about the SQE process and how it works and what it entails, if you want something specific about the preparation as we're going towards the first sitting of SQE1 now in July, anything that you want to talk about that is SQE related, then we can chat about this. That's what I'm here for. And if we've got members of the community that are interacting with each other in the chat, that's awesome as well. And we can pick up on those discussions and follow up with what people want to follow up. Now, by the way, if you guys are looking for any last minute resources as you're gearing up your prep for SQE1, I've got a couple of things to recommend. These are nobody's sponsoring this particular live stream, but these are people that have been involved with the channel in the past, so you will have come across them. One, and I'm going to put links down in the description to this. The best titles that you can take to revise and to prepare in a hurry, I consider to be the Revise SQE books. So if you guys are members of the newsletter, I've got a 10% discount code in the newsletter for you as well. If you're not yet members of the newsletter and you want to grab the discount code, just subscribe to the newsletter now. Newsletter@glinktis.co.uk, email with the word subscribe in the subject matter, and I'm going to reply back to you to enroll you, and you can have the discount code so you can get the titles from Revise SQE. They have been for a while and still remain the best titles that one can use for revision, especially if they're in a hurry as they're getting towards their exam. If you want MCQs, I mean, we've got all the MCQs that are coming out in the newsletter that are also available on the website, because I've got all the archive there that you can go through them yourselves. I've got plenty of live streams that I've done already where I'm going through MCQs, fresh ones, or from the newsletter or from other things that you can revisit or look at them for the first time as you're going through the YouTube channel. But if you want to attempt a mock exam, or you want to have either a mini mock or a full mock, and you want to try this out in exam approximating conditions, so you got like the clock ticking and you're trying to answer those questions under pressure, I recommend law drills. So I'm gonna put links to these guys at the bottom as well. I've got a discount code in the newsletter for these guys too, so you can purchase access to the website and do as many MCQs as you want, or you can purchase the mock exams that they've got that take place in timed conditions. And since we're gearing up for SQE1 anyway, I think the best thing that one can do for SQE1 is practice, practice, practice. And it is not simply about the substantive knowledge of the topics in the FLK that you're dealing with. It's also being able to respond to those questions at speed, because the exam is a timed exam. You've got a timer kicking, and you need to be able to make decisions, read the question, understand the topic, select the best possible answer, and do this quickly and proceed. Unfortunately, the way they set it up, thank you, SRA, does not allow a great deal of time for reflection. And the only way to prepare yourself adequately for doing these things at the volume that you need them and at the speed that you need them to do to succeed in the exam is to do it by doing a lot of MCQs, a lot of mock tests, and all the rest of it. So guys, thank you very much for joining me today. Hopefully you found the stream useful. If you did, hit the like button so you tell other people that you're having a good time here. Drop me a message down in the comments under the video, and I will see you guys next Tuesday again at 12:30, hopefully from a painted room, right? See you soon.